Current insolvency assignments. A warning to all creditors to stay in the present to preserve your rights. Every licensed insolvency trustee maintains a website listing their current insolvency assignments that are noteworthy or of public interest. Today I want to tell you about a recent case of ours. It is not of public interest, but it is noteworthy. Notwithstanding the large volume of receivership and bankruptcy case law, the issue we came across was novel and never decided in court before. Mr. R. was the sole shareholder of a company that serviced the construction industry. The company became insolvent, could not continue, and ceased operating. Mr. and Mrs. R. were both officers and directors of the company. In addition to their personal debts, which were significant, they were now also faced with extensive claims against them in their capacity as directors. We met with Mr. and Mrs. R. and advised them that they should not declare bankruptcy, but rather attempt to avoid bankruptcy and restructure by filing a joint proposal under the Bankruptcy and Insolvency Act. Their affairs were complicated, and they required an immediate stay of proceedings to deal with all the lawsuits against them. Therefore, we first filed a joint notice of intention to make a proposal, which is the first step, and provided them immediately with an initial 30-day grace period, where no creditor could begin or continue legal proceedings or enforcement against them, while we were working with them to finalize their restructuring proposal. As trustee, we served the notice of intention on all known creditors by ordinary mail, as we are required to under the Bankruptcy and Insolvency Act. The notice that was sent to the creditors did not contain any proposal whatsoever because it had not been written yet. This is standard practice. In response to the notice of intention, we received from an agent for a specific creditor 2 proofs of claim, one for each of Mr. and Mrs. R. The agent also sent a voting letter. It asked the trustee to count the creditor's vote with respect to the proposal of Mr. and Mrs. R against acceptance of the proposal made as of the 8th day of June 2016. There was only one problem. There was no proposal made either on the 8th day of June 2016 or at the time that they sent their letter and voting letter. We immediately wrote to the agent advising that the trustee's position was that because no proposal was yet in existence, the vote was invalid and that they would have to provide a proper voting letter once they received the proposal. Mr. and Mrs. R filed their proposal on July 7. We then served the proposal and all related documents, including a notice of meeting of creditors, on all the creditors, including this specific one. We received and heard nothing further from the creditor, either directly, by one of their agents, or by their legal counsel. The meeting of creditors proceeded on July 27, and at the meeting, the requisite majority of creditors accepted the proposal. So now off to court we go for approval of the proposal. Our motion for approval of the joint restructuring proposal was opposed by the creditor. Our lawyer made various submissions regarding that creditor's vote by stating that it was not valid, that the creditor was advised of this and did nothing to file a valid vote, and they failed to attend the meeting of creditors. The creditor claimed its vote was valid and ought to have been counted. So what did the court decide? The court found that the agent's purported vote was on its face defective. There was no proposal of June 8. The creditor or its agent had never seen the joint proposal when it voted. The trustee was right to reject an obviously defective vote. The trustee made its position abundantly clear to the creditor's agents, and the creditor had every opportunity to cure the defect, and it failed to do so. The court also found that the trustee was correct in rejecting the June 22nd vote, and RBC, the creditor, was not denied due process. The motion for approval of the joint proposal was granted, and the trustee was also awarded costs. So what is the moral of this story? The first moral is you need to know the rules of the game you are playing. And secondly, never fall asleep at the switch.
I hope you enjoyed the video. The Ira Smith team is available to help you at any time. We offer sound advice and a solid plan for starting over, starting now, so that you'll be well on your way to a debt-free life in no time. For more information on a no-cost basis, please visit our website or call us. Our website and telephone details are coming right up now.